the judge said outright, they said, so you think you're going to lose the LA trial and that's why you've put in the Chicago trial? Just said it straight up, bold. Stop saying the same thing. It was almost like cut the shit. He said, so you think you're going to lose the LA trial? That's why you're doing this. And I swear the courtroom laughed. It was almost like a moment of comic relief. Like everybody that supports Durk in that courtroom was almost like finally like vindication. We're kind of hearing what we want to hear.
Well, you know why that is, Trapper Ross? Because they don't have a case to win. You're going to notice by these motions that they have decided to give us. Let's go. Now, this should be funny as hell. So the feds say that we want a limited gag order prohibiting prejudicial, extrajudicial statements. Ain't that something? So America, the feds of America, say this. Let's get to it. Despite the imminent trial date, counsel and surrogates for defendant Banks continue to engage in public press operation that creates significant risk to the jury pool and the fair administration of justice. As a result, the government respectfully requests that the court impose a narrow gag order to prohibit further unnecessary extrajudicial statements about the case. A defendant is entitled to zealous advocacy, including counsel's forceful argument on the briefs and in the courtroom, but the right to a fair trial does not include litigation through prejudicial and extrajudicial statements on the eve of and during the trial, as this court previously recognized in a separate case. A flurry of publicity on the eve of the trial threatens creating a circus-like environment that would deprive the parties of their right to a fair trial. Until now, the government has declined to seek judicial intervention despite the defense's repeated inflammatory public comments. The government twice inquired whether defense counsel would agree to a limited order prohibiting the parties from making extrajudicial statements that could prejudice the jury. Defense counsel declined, and the government respectfully submits that court should now intervene. The argument. Trial courts have an affirmative constitutional duty to minimize the effects of judicial pretrial publicity. It talks about a bunch of cases we don't give a shit about, but they're saying that they need a limited gag order, and it's necessary. From the inception of this case, defendant Banks has attempted to use his influence in media access to influence public opinion about the strength of the case and at times to malign the government. For example, defendant used a social media account with nearly 15 million followers to publicize the first motion to dismiss the first superseding indictment, falsely claiming the government was using this murder case to criminalize black artists for their creativity, which you literally are, because we're going to prove it with the damn songs you guys are going to try to use, AKA the people who are going to break it down for you. While the motion was pending, defense counsel appeared on a popular podcast with hundreds of thousands of views providing commentary about the merits of the case. Then, following the filing of the TSI, counsel issued a press release using defendant Banks' social media account that criticized the new charge, calling allegations false and lipstick on a pig, and contained other rhetoric suggesting the government was scrambling and pathetic. I mean, you know, the judge told you that y'all were in fear of losing this case, but it's fine. Counsel then gave an interview where he criticized the government, boasted that the defense have been defeating the government on so many legal issues, and claimed the community, including law enforcement officers, opposed the charges against defendant Banks, walking up to counsel saying, "Free Durk." Then on June 26th, in light of these and other publicity disseminated statements, the government proposed a joint gag order, which hell no, they said. Following the July 14th hearing before this court, defense counsel conducted an impromptu press conference on the steps of the courthouse last week. And this is funny. This is just funny as hell. Let's see. That's the DJ Academics one. I want to go to this one to see. We're going to have to. Hold on. So they're talking about basically the because I don't have the right to play some of this stuff, which is funny because a lot of these cats use my shit, but whatever. Anyways, it's a bunch of academic shit where Drew Findling is popping his shit. And other motions and parties intend to file. Defendant Banks' counsel indicated that defendant opposes the requested relief for the reasons set forth below. We want you to basically kill this. But we're going to destroy what the hell he's talking about, because there's one thing that the feds are doing that they don't want to bring up. It's funny because the feds, when they arrest anybody, they put it on their damn website as a press release. then they are able to go ahead and say certain shit, right? The feds are literally saying to the judge, let us bring the jurors through the back door and hide them and make sure nobody knows exactly who the hell they are, what they do, all of these things. When literally you could just get rid of all of that shit as far as what they do and all of these things and still go on with the case. But the feds are trying to bring them in under the suspicion that if they don't find a guilty verdict a non-guilty verdict for this shit, that basically they're going to die or be harmed or be stalked or be harassed. Because somebody who was a super fan, and I'm assuming they're this color, decided to call and harass the damn judge and the damn lawyers, but no arrest was made. No arrest was made, which means it was probably some stupid kid. But they still do some more BS. Let's see this. Government's motion in limine number 2 to exclude irrelevant evidence and arguments pursuant to 403. And it's talking about this is the Fed's motion. So let's see what the hell they got going on. Trials and courts have a duty to forestall or prevent jury nullification, including by preventing impermissible defense questioning or argument. Then it goes on to say the evidence not relevant is not admissible. Yeah, we don't give a shit. Unfair arguments related to the government's charging decisions and non-operative indictments, including the contents, allegations, charges, and timing, are irrelevant and will open the door to severed vicar evidence. The government's charging decisions and prior iterations of the indictment are irrelevant to the pending charges. Such arguments have no place at trial. Defendant Banks, for example, has cited to prior iteration of the indictment to falsely claim the government presented false evidence to the grand jury to indict him. Defendant Banks has made similar claims in multiple filings, as set forth in the government's motion in limine seeking a limited gag order. Yeah, this is just talking about the damn gag order. Yeah, we don't care. Because it's talking about, listen to this shit. And this is why I'm like, I don't know if I'm going to be able to go, right? Make these and other, let's see. These arguments and assertions are false, irrelevant, and will undoubtedly confuse and mislead the jury. Indeed, if any defendant were permitted to make these or other arguments attacking the government's motive for charging this case or any particular defendant, such arguments would open the door to evidence the court has severed from the August 20th trial, specifically that evidence linking defendant Banks and his close associates to broader criminality in addition to his alleged role in SR's murder prompted the charges in this case. Celebrity endorsements, fan support, and celebrity business or music collaborations are irrelevant. In addition to the public statements designed to undermine and denigrate the charges against defendant Banks and his co-defendants. Defendant Banks and his representatives have made a variety of public statements. There's a wide public opinion to free Durk. A defendant's celebrity endorsements and fan support are irrelevant to any fact at issue, should be excluded at trial. It goes on to keep on saying, defendant's charitable and philanthropic activities are irrelevant to this murder case. Basically, they're saying anything that can make Lil Durk look good, we don't want none of that shit in here. Evidence related to punishment, family, and other irrelevant personal factors. Defendants should be precluded from referencing any potential penalties, including a custodial sentence that defendant might face if convicted at trial. Defendants should similarly be precluded from offering evidence or argument about their family, age, and they talking about, oh yeah, we get your ass, you're gonna be done. So yeah, this is pretty damn stupid on behalf of the feds. I'm gonna be honest, because they're talking about basically not letting people come in and say shit about Durk and how good he is and all this shit. Though you guys are literally trying to have the jury act like they're about to get killed before they even go and stand on trial. Like before they even go sit as jurors in the trial. Remember, they're trying to bring the jury in through some secret covert shit like, oh, if you don't find him guilty, you're going to be fucking killed. Like, come on, bruh. That's that bullshit. So if he gets found guilty, they don't want anybody coming in there talking about family and all of this shit and everything, which is funny because you write the letters to the judge and all this stuff and talk about how good somebody is and all this stuff before somebody is sentenced anyways. So there's that. And trying to stop that shit is kind of funny. But even if, let's say Durk does lose this shit, the appeal process is going to be so damn crazy that the feds are probably going to have to drop charges when they decide to retry it if he's found guilty, which I've been telling y'all for a minute, he's not going to be found guilty. So let's just get on with this next BS. Terrible, I'm telling you right now. Government's motion in limine to exclude and/or limit defendant Banks' proposed expert testimony. We just gonna get all the way. Let's just, it basically goes on to say that Lil Durk got 4 expert witnesses to testify at trial. First, he has noticed Dr. Lance Williams as a proposed gang and drill rap expert, right? Among other things, Dr. Williams' proposed opinions include that drill rap or reality rap, which originated in Chicago in the 2010s, is a distinct popular culture phenomenon and music genre that should be analytically distinguished from actual gang criminal activity, despite both references similar imagery involving gangs, violence, and weapons. He has also proposed to opine that participation in drill rap culture does not necessarily indicate participation in gang criminal activity or membership in criminal organization. Second defendant has noticed Dr. Eric Nielsen as a proposed rap expert. Like Dr. Williams, Dr. Nielsen's proposed testimony includes opinions that rap lyrics should be understood as fiction and often barely resemble the lived realities of the artists performing the lyrics, and many rap lyrics are pure fictionalizations and have no basis in reality, which is true. His proposed testimony also includes the opinions that many rap lyrics often depict hyperbolic images of violence, profanity, use of firearms and drugs, and that it is commonplace for rappers to perform a beef when in actuality there is none. Yeah, there are fake beefs that are going on in the industry. Y'all wouldn't know that if you, never mind. Third, defendant has noticed Miss Chantel Britt as a proposed music management expert to opine about professional norms of successful artists in the music business. According to Miss Britt, this includes her opinion that the hip hop rap genre has not only normalized the use, possession of luxury items, including public display of cash, jewelry, watches, designer clothing, expensive vehicles, and private planes, but artists are now expected to maintain a certain perceived lifestyle by their fan base as a greater strategic branding strategy. That's true. And fourth, defendant has noticed Mr. Matthew Busser as a proposed entertainment law expert. Like Miss Britt, Mr. Buser has been noticed to provide expert testimony regarding the industry norms and business structures in the music industry. This includes the strategic choice to feature an artist on a particular song, and that before a song is widely released, the lyrics and production are generally subject to a thorough review by executives, legal, and other corporate parties. AKA, a feature costs money, and did you pay for the shit? For the reasons explained below, the government requests that the court exclude in full and/limit the testimony of Dr. Nielsen because it is cumulative that Dr. Williams on the fictionalized nature of rap and otherwise unsupported, unreliable, irrelevant, untethered to drill rap and violates Rule 403. Exclude in full or limit the testimony of Mr. Buser as cumulative to Ms. Britt's proposed testimony on music industry norms and is otherwise irrelevant and misleading, and exclude any expert from opining that about the use or admissibility of rap lyrics in other cases or jurisdictions because such evidence is irrelevant, misleading, confusing, and otherwise violates Rule 403. Argument. Trial courts act as a gatekeeper to exclude expert testimony that does not meet the relevancy and reliability threshold requirements. Right. Dr. Nielsen's proposed testimony should be excluded in full because it is cumulative to Dr. Williams' proposed testimony on the fictionalized raps. Yeah, this one might work because they're basically saying, yo, Dr. Nielsen and Dr. Williams both are about to come in here and do the same damn thing. I can see that one getting through. Moreover, Dr. Nielsen's speculative testimony about rappers' fake beefs would be unduly prejudicial to the jury's factual determination whether defendant Banks and OTF had an actual feud with TB, or, as the defense contends, whether defendant Banks used a fake beef to commercialize his image. But such determination does not require expert explanation. Rather, it is commonplace factual determination best left for the defense counsel's closing argument. Finally, Dr. Nielsen opinions that depictions of violence are one of the cornerstones of the rap genre, born out of a long history of African American oppression should be excluded as irrelevant and highly prejudicial, as it invites improper considerations of race and violation of bedrock principles of a fair trial. Yeah, bullshit. They want Mr. Buser gone because basically his testimony regarding industry norms and business structures of artists and supporting personnel in the music industry, the extent they overlap with Mr. Yeah, that's true. So we're going to leave it right there because they're basically saying you're doubling up on people saying the same shit. Here's why they had to do it. And some of you guys will go, oh, well, Nash, the feds kind of got a point. Why are you trying to make the same point twice with the same person? Because if you kick out one, you might save the other. It's like when your kids get smart enough to start asking you for shit, they ask you for two things. It's typically the second thing they want. They'll go, Mommy, Daddy, can I have $20 for some goddamn V-Bucks? Or Roblox, whatever the shit that shit is called. Oh, and you go, nah. Well, can I have 10? And you go, all right, I got 10 for you. Your ass know you got played by the time you give them the $10. You just don't want to get the kids no goddamn thumbs up saying, damn, you got me. That was pretty good. But that's what's going on right there. To have two people come speak to the same shit, yeah, it's repetitive, but it's because you guys might kick them off. The reference, the letters that they have with the first doctor, he done fair trials for 30 years. So he ain't going nowhere. And the feds had to acknowledge that. I just didn't feel like making that a longer clip than it had to be. But let's continue on. Kind of fly by this shit. Government's motion in limine to preclude defendants from offering their own prior statements, which is crazy as shit. So let's see what's going on. This is a gang murder case involving a subgroup of OTF members who plotted and conspired to kill a rival. At trial, the government intends to introduce various admissions made by the defendant and other co-conspirators to show their involvement in the stalking and murder conspiracy, their motive for killing TB, basically. These out-of-court statements are not hearsay when offered to the government. However, subject to narrow rule of completeness, the law does not permit a defendant to offer his own prior statements for their truth. The court should preclude the defendant from attempting to do so here, given the limited admissibility of defendants' out-of-court statements. And it talks about on July 21st, 2026, defendant Banks provided a production of reciprocal discovery to the government that did not include any statements of the defendants other than a broad statement that the defense precludes the entirety of the government's discovery productions to Mr. Banks. The majority of the statements the government will seek to admit at trial are admissible as party admissions under Rule 801D2A. And then the co-conspirator shit gonna come in under another one. The defendant may not offer his own statement in the evidence without subjecting himself to cross-examination. Oh, shit. So they're basically saying, yo, you can't bring in shit that you said without getting your ass up on that stand. And this probably will be thrown in there. I don't know. That's going to be a hard one. They talk about other cases with Fernandez and Ortega. The court should admit defendant statements only when offered by the government. Here, the government intends to introduce various statements made by defendants and other co-conspirators to prove the elements of the alleged crimes. To the extent defendant believes the rule of completeness applies to the specific exhibits, those issues should be raised with the government in court by trial. Then it talks about basically defendants seek to admit their own statements during government's case in chief during cross-examination of witness. The defense preview to the government and the court prior to each trial. So let's just get through this shit. We ain't worried about that. Let's go to this. Government's motion in limine amid defendant Banks' Piss Me Off music video and audio. I'm curious what the hell they're going to talk about. After the November 2020 shooting of DB, a.k.a. King Von, defendant Banks and other OTF members faced immense public pressure to exact revenge for Von's killing. That pressure came from fans and foes alike. At trial, the government seeks to admit a single music video with its audio, defendant Banks Pissed Me Off. That is highly probative to demonstrate to the jury defendant's message following DB's death. So this is really what kicked it off. That defendant did, in fact, intend to slide for Von, and others should do the same. Such evidence is direct evidence of defendant's involvement in the criminal conspiracy and otherwise inextricably intertwined with the charges in this case specifically. In October of 2021, defendant released a music video called Piss Me Off that attempted to turn that narrative on its head. In the song and video, defendant affirms his resolve to avenge Von's death and criticizes those who would rather party in clubs and post on social media. Rather than basically getting a gun and sliding, you know what I'm saying? In the booth, I mean, in both. It's in the booth. In both lyric admissions and visual depictions during the song and video, defendant publicly pronounced his motive and intent to slide for Vine, and with striking specificity instructed to others to do the same. Grab a gun if you ain't with it. Put up money for a gun. Put up money for a haka. Put up money for a buy. If I don't see you on the regular, but I see you yelling Vine. By paying homage to Vine's life through attire, memorial jewelry featuring King Von lookalike. No, that was actually Vine, you fucking idiots. That was literally Vine. That was just this how you know the feds don't do shit. That was literally King Von. That wasn't no damn lookalike. They just used the old video. Yeah, defendant's admission. Man, fuck this shit, bro. This is trash. So y'all just wanted on here because he said those would be in the club even though their man's dead instead of offering to get back on their man's. Defendant critics. Man, no. Let's look. Why you niggas post the sun? Why you niggas post the truth? Why you acting like she's porters if you do hop in that coupe? Man, nah. I don't see you on the regular, but At trial, co-conspirators are anticipated to testify that True is Von's son. Oh, and what if that's not his name? Then they talk about all this shit. Finally, Bride sentiment from both admissions and imagery for the music video in line with other admissions. But man, all them damn videos look the same, bruh. Literally, majority of them videos look the same. Come on, lyrics in the song that call for revenge and the death of Vine, as well as displays of large amounts. But I think they're gonna let this shit in just basically from the beat alone. But let's get on to the last damn thing that these people decided that they wanted to do. This is gonna be good. Government's motion in limine to admit self-authenticating business records. Oh, this is going to be interesting. Let's go. The government hereby moves to introduce business records. Let me move that out the way. From multiple organizations at trial under the self-authentication provisions of federal rules of evidence. We don't care. Okay, what the hell is it? A record-generated electronic process. The government has produced in discovery business records, the custodian of records, or their qualified persons from the following organizations: Starjet, United Airlines, Southwest Airlines, REI, Uber, Verizon, VM, Exotic Rentals, United Airlines, Signature Flight Support, T-Mobile, Verizon, T-Mobile, Verizon, AT&T, Verizon, AT&T. We don't give a shit. Basically, in order to admit the above references, this shit gonna get in because this is the business records that they need to prove about payments of everything. The feds are flat out full of it. In one motion, they say, let us bring these things in. But at the same time, when they bring certain shit in, they don't know what the hell they're talking about. There's slang that is essentially beholden to certain regions. It just is what it is. Even different gangs use different slangs. If you're a Crip, you saying C with everything. Y'all done heard C-Mac say shit. When y'all hear the Blood say stuff, they replace C with B and say shit like that. So they don't know what they're talking about. And that's why they hire people for interpretation from different cities every single day to break down what the hell shit means, because slang is slang until you don't know what the hell slang is, aka colloquialism. So when the feds are doing this shit and they're trying to lie and add in shit that they know that they're not supposed to add in, but they're trying to, you start to see that their main shit is for people to come up and say, no, this song right here, yeah, this song right here, bruh, this song, it means this because these lyrics mean this and these lyrics mean that. If the evidence was so good, and I keep saying this shit to y'all, you wouldn't need no damn lyrics. You wouldn't. If these dudes had the text messages and the witnesses that they said they had, they wouldn't need no damn songs. Think about it this way. Durk done rapped about Von and all this bullshit and everything in probably like 30 damn songs. So what are they really trying to do? They're trying to bring it in there so they can put the visuals in there. They want the video to play. They don't give a damn about the song. They didn't even know that the damn video that they were playing, they were watching, wasn't a lookalike. It was actually him. This was just B-roll footage from older goddamn videos. That's why the crowd looks different. That's why the lighting is different. If it was a goddamn stand-in, you would have seen Von standing with everybody. That doesn't make sense. It's the equivalent of you hiring somebody to be an actor of a family member that's no longer here, but all of a sudden, all the damn video clips that you have them in, they're not actually in there. Wouldn't you hire the person to be around y'all? Go back and watch Piss Me Off and tell me I'm wrong. Von ain't even with Durk. So, nah, man, the feds is full of shit. They don't even know what they talk. Once again, feds don't know what they talking about all over again. So they're going to get crushed on that shit if they bring it in. Because as soon as they say, oh, this right here is a replica King Von, and the person who edited the video pops up and goes, actually, no, sir, that's actually B-roll footage from some shit we had already did. And let's be fair, square, obvious, and honest. Had Durk never made songs about people kicking ass for Von, people doing things for Von, everybody would have looked at him like, what the hell are you doing? That's what's called reality rap. That's the part of that shit. But they won't bring in the songs where Durk is talking about, man, y'all want us to do dumb shit and then y'all gonna turn around and laugh at us in the same damn album. So if I'm Drew, I'm looking at songs where Durk has talked about, bro, we not doing shit because we know the feds watching, police watching, and y'all gonna clown us if we do something. So, nah. And then them trying to sneak in shit, gang shit that wasn't even supposed to be there. Yeah, I expect the damn judge to really rip the feds a new one. The judge is already pissed off at him any damn ways. So let's go with the damn trial. I will see y'all in the responses because I know that Christy and the other lady, they're typically the ones doing the writing. So what is her name? Hold on, let me find it. Marissa. There we go, Marissa. Anyway, subscribe, turn the bell to notified, share to keep your people aware. Lordy, Lord. What the hell is going on down in Houston, man? H-Town. What the hell? Cartel both facing a life sentence for some shit he did to his baby mama according to the state. And I'm going to be honest, watch this shit with caution. Click right here to see that video or click right here for the playlist, and I will catch y'all in the next one. Y'all come on back now.